Good afternoon, Mr. Khallil.
Good afternoon, Chief Justice, and good afternoon to all the commissioners and our JP and KZN as well.
How do you feel today? Are we well?
Oh, it was hectic. I hardly slept. Had to reflect on a lot of things, and correctly so, I think. And yeah, but it's been really, really hectic. But thank you. I am fine.
All right,
And
good.
yes.
Well, I promise we won't keep you long this afternoon.
Yes.
And we just spoke to you what was it, 24 hours ago, literally.
Yes.
So we know exactly, we remember vividly exactly who you are.
Yes.
So I'm not going to put anything to you.
Yes.
And I will give JP, the KZN JP and her premier, and any other commissioner who may have a leftover question from yesterday to question you. But it should not take long.
Yes, certainly. Thank you, Chief Justice.
On that note, JP.
Thank you, CJ. Good afternoon, Mr. Khallil.
Good afternoon, Judge President.
Yes, I watched the interviews yesterday that you were interviewed for yesterday. Yes. And you were not recommended for the Eastern Cape for various reasons other than the reason that you have not acted in that division. So I make the point that it was not for that reason only that you are not recommended according to how you fared from what I saw on the interview. There were various lot of concessions that you made about your readiness and ability. Why would you think that would change for KZN?
Sorry, you're saying I made lots of admissions regarding my ability?
Of readiness to becoming a judge?
No, I don't think I made any admissions. The admission that I made was, Judge President, I was asked a question, if I remember correctly, whether as a magistrate, just purely as a magistrate, whether that would prepare you for the High Court. And I indicated, in my view, not. One must have acted in the High Court to understand and appreciate the intensity of the work.
Perhaps to rephrase my question then, it will be, yesterday this body decided not to recommend you for appointment in the Eastern Cape. Myself and the Premier are the only two people that were not there yesterday.
Yes.
Why would you think that would change today?
I would think that if I'm asked questions about the work that I've done, what I've disclosed in my CV, and asked more questions, perhaps that may bring to the fore other factors. But yes, sorry, JP. Yes, just about yesterday, upon reflection of what was discussed yesterday and what I became aware of, which was not known to me at the time when I accepted the nominations for other posts, I would certainly not have accepted that. And what coming from a senior judge like Judge President Mlambo, although he did not provide any prescripts, just listening to his advice, I think it would be unbecoming of me not to have considered that last night and to have reflected upon that. And I think it's a reflection on my character if I did not do that. And I wanted to say to the commissioner, I meant to say it at the end of this interview, but perhaps I could say it now, that I withdraw the acceptance of the nomination for the posts where I have not acted as a judge of the High Court. I understand and appreciate, and I understand that it was not put forward as a criteria by JP Mlambo, but I understand and imagine as a junior judicial officer, if I did not reflect on that, it would reflect very badly on me. So I just wanted to say that I do indeed do so, not because of any pressure, but because of what was discussed, and I understood what was discussed yesterday, particularly relating to being in the High Court in a division where I've not acted.
Sorry, JP, may I just get clarity? Are you saying you are withdrawing your candidature for the position advertised for the Limpopo division?
And Western Cape.
The Western Cape as well. All right. We have noted that. Thank you.
Yes, and I just want to repeat, I do that freely and voluntarily based on what what I learned yesterday, which was not within my knowledge at the time when I accepted the nominations. Thank you.
Thank you, Mr. Khallil. Carry on, JP.
Thank you. And lastly, on my side, CJ, Judge President Mlambo brought it to attention that for a person to act or even to be nominated, they get identified by their peers. Your nomination letter is from your ex-boss, if I may say that, the previous.
Yes.
Yes, it sounds like a motivational letter for promotion. How do you compare the two? You know, your peers identifying you for nomination, various advocates or various other magistrates other than your direct boss that would write the motivation for you.
Yes, I take that point, but what I can comment on, JP, is nobody would know you better than your immediate supervisor or boss, as you put it. And it wasn't for the first time that he had nominated me. He's left the profession quite some time. And I do understand, and I've received from the commission comments on my nomination. And I omitted to mention that I thank all the law bodies for having taken the time to have gone through all my judgments, my CV and my history for those two posts and to have made comments on that. For me, initially, JP, I was really happy. You know, when I was shortlisted, when I learned I was shortlisted for so many posts, and in my mind, that served as some confirmation for me that I would not have been shortlisted had the Judicial Service Commission not seen value in me. So I truly appreciate that, and coming from the background that I do come from and all the various comments, it adds a lot of confidence, and I think it can be an example for other magistrates as well, that the way you try to work as hard as possible, minus what I didn't know at the time when I accepted the nomination in other provinces, that you can be given recognition for that.
Thank you, CJ, that's all.
Thank you, JP. Do you have any questions for the candidate Premier?
CJ, no, thank you very much. I don't have a question.
Thank you, Premier. Commissioner Hassan?
Thank you very much, CJ. Over here, Mr. Khallil, Commissioner Hassan.
Yes, yes.
Some questions I had, and I didn't want to pose them yesterday because we were dealing with the Eastern Cape Division, and today, of course, we're dealing with KwaZulu-Natal, and therefore I want to ask a few questions related to the work that you've done within KZN.
Yes.
If I'm not mistaken, Mr. Khallil, you've dealt with some of the July 2021 unrest and some of the key cases in Phoenix, if I'm correct.
Yes, I have.
Right, so protest, as we know in South Africa, is almost part and parcel of our history, but it's also part and parcel in many ways of our identity as South Africans. It's a right enshrined in the Constitution, etc., etc. But so often it's also the last point of call for our communities, especially young people who tend to be at the forefront of service delivery protests, etc., etc. And we've also witnessed, Mr. Khallil, police who tend to be very heavy-handed and often arrest community members en masse at a protest. So I'm interested in the context of July 2021 and the Phoenix cases as well. For the purposes of conviction, which legal principle would you use to distinguish between a guilty person and those who happen to be exercising their right to protest, and those who are actually guilty of the crime? We know the doctrine of common purpose is quite a controversial one, especially in our history, legally speaking. But I'm very interested to know what legal considerations go in, because you've dealt with some of these cases, between those who are guilty and those who were just at the protest. Thank you.
Thank you. I don't think it happened, Commissioner, in the context of a protest. There was large-scale looting, as we all saw it on television. There was a large scale of violence, and I dealt with the matter in the context that certain alleged perpetrators were arrested, and it was at the time where the police were largely absent or even overwhelmed. And a lot of I think if I remember correctly, there were 38 murders in Phoenix. And the army was at our courts, just to give you the context of those matters. The reason why I dealt with those matters is some of the other magistrates that I allocated the matter, or I intended to allocate the matter, were afraid. They had family living in Phoenix and friends. So as the acting chief magistrate, and I've done it on many other occasions, I had to lead from the front, and I think I spent almost 2 months just dealing with those matters, and in a lot of those matters it was mainly senior counsel. So that is the context in which I presided over those matters, or quite a number of those matters. And it was really hectic. And the one matter you asked me about, it is a matter where I had refused bail, because the finding I made on a prima facie level, and after having watched, it's not often in a bail application where you have the opportunity to actually watch exactly what had transpired. And there was a very senior counsel in the country that I think came out of retirement. He did the matter, but in any event, he withdrew. But when I saw that video, it causes you to go home, you cry, you ask, but what motivated other human beings to act in the barbaric manner that they acted? And the finding that I made was on the basis of common purpose on a prima facie level. I accepted that the state had a strong case. I refused bail on various grounds. It's like a 52-page judgment. And the one finding I did make was that the attacks, in my view, in terms of the evidence, were racially or based on racial profiling. That is the number of cases that I made. The other difficulty was that in so many of these matters, lots of the suspects were allegedly assaulted in prison. They were not given sufficient food. They were robbed. And it was so many dynamics in those matters that I eventually had to take the course of having the head of the Correctional Services subpoenaed to court to deal with that, to deal with those issues. But the short answer is that in exceptional circumstances in the bail legislation, and I found these to be exceptional circumstances where it would cause public outrage, where it invokes a lot of, basically outrage and public disorder. And because of the strong prima facie evidence, in my view, and I use the one leg of the bail legislation, which says only in exceptional circumstances may you do so. It's been referred to as the lynch law or so, but I thought it best, after having considered all the evidence, that there were no exceptional circumstances which justified the release of the applicants on bail. So it was really hectic, but it's fine. I mean, we all deal with these types of matters. But during that period, we've had magistrates being disallowed to come to court on public roads, the senior magistrates, couple of them. And they asked me for, at that time, if you remember, during COVID-19, you have the COVID permits that were issued. I discussed it with them and I said, I find it unacceptable to give any magistrate a permit to come, because do you need a permit to travel on a public road in South Africa? and these were two senior African magistrates. They understood it, toughened them up, etc. as well, and there were no problems. But it was hectic psychologically, emotionally. I've never ever presided over matters like those matters.
Sorry, Chief Justice. If I could, I know the agreement, but sometimes sort of try to help. I think the question is, what is the legal principle to distinguish the guilty from the not guilty? Because so far you've identified common purpose. Common purpose expands the net of the people that are responsible beyond those that can be immediately identified.
Yes.
And it's controversial from as far as Safatsa. The question is, how do you distinguish the guilty from the not guilty? We have a mass uprising, a mass looting. You don't know who was looting, who was not looting. The police have just arrested 1,000 people.
Yes. Thank you, Commissioner. Can I just say that perhaps I should have indicated this, that in quite a number of the matters, it was based on a Schedule 6, what we commonly refer to as the Schedule 6 bail application, where the onus is on the applicants. The applicants procedurally started first by handing in affidavits and saying exactly what you have suggested, that there was looting, etc. But from the videos that we watched in court, there was no such looting. For example, you just find 4 youngsters walking on the road, and suddenly a whole group of people come in a bakkie, all armed, and start attacking the 4 youngsters. They run, they come out of where, or they weeded out, and then a continuous stabbing by one person, then another person, then a gunshot to the face. It was in that context, I'm saying, it wasn't as if there was a protest and there were certain people and others were just hanging around. It was an attack on persons who were just walking unarmed, no evidence of any looting, nothing at all. So I used a common purpose on a prima facie level to say that even though one person may not have stabbed the deceased, for example, in one of the cases, but the others by helping to weed them out, the others by perhaps maybe shooting them or shooting one person, the others by assaulting them or blocking their way. So it is on that basis that I made the prima facie finding. So it wasn't in the context that people were looting and others were just standing by and where the police arrested them.
CJ, just my second question. I'm not going to berate the point on the legal principles. But Mr. Khallil, you've also presided over a number of equality cases, particularly those that have been constitutional in nature, dealing with racism in social media, which has been quite interesting given, of course, we're seeing a lot more proliferation of hateful content online. And I think some of your findings have gone quite a long way in demonstrating that there's no place in a democratic South Africa for racism, of course, but particularly also for racism as they are in social media posts. I mean, the Penny Sparrow case, if I'm correct, you presided over or participated in some shape or form. And that, of course, changed society. And just before I ask my question, it's related. It's also an example of how powerful progressive judgments can be and the kinds of messages it can send to society, that there are consequences for this kind of behavior. So, Mr. Khallil, I'm interested in how long you've been a chief magistrate and how long you acted as a judge and how you think that this has prepared you for a potential seat on the bench. Thank you.
Thank you. For the past 21 years, I think I've been a magistrate. And out of those 21 years, 15 of those years have been in management at the lower court level, at the magistrates court level. I've acted as chief magistrate at Pietermaritzburg for a few months. I've acted at Durban, and currently I'm acting for almost 7 years at Khallil. That post has not been advertised because of the relocation of that post to the far northern areas of KwaZulu-Natal, areas like Umzinyathi, Umzimkhulu, Zululand. They don't have a chief magistrate there that is close to those courts. So it has been decided that that post will be relocated and then the process. So it's for almost 7 years I've been an acting chief magistrate. The Equality Court cases, yes, the most recent one I've done is on albinism in South Africa, and that's a huge problem. You know, we see these matters on the media, and it was quite a taxing case. And with respect and the greatest humility, I didn't submit that judgment because I delivered it after the acceptance of the nomination and the completion of the questionnaire. But you're correct in that in all the Equality Court matters, you're dealing with constitutional rights. You're weighing up one right against the other rights. You're contextualizing the disputes in order to arrive at a fair and just conclusion. These matters as well, it puts you under a lot of pressure because of the findings you make and your judgment. Like in the Phoenix unrest-related cases, I was advised by security not to go into the Phoenix area for almost a year and a half after I finalized these matters. So I think it has prepared me quite a bit, especially the Equality Court, because the Equality Court has a very similar powers to the High Court. In the sense that you may grant prohibitory interdicts, you may grant declaratory orders, you have the option of getting progress reports on the various orders that you do indeed make. So, for example, if you tell somebody or you order them or direct them to apologize, you direct them to put up a video, for example, to apologize in the same way in which the initial video caused the complaint. You can ask them to do so by a certain date for them to file in all these progress reports, because it's well and good giving the orders, but for the orders to have meaningful effect, I think you have to have these progress reports. So I think all these matters, just very briefly, has given me a lot of experience, and it has opened up my insight. And if one looks at the comments made by the various bodies on my judgments, I did say initially I thank them because it gives you so much of confidence that others would have looked at your judgments and they would have made various comments on your judgment and going through that.
Thank you, CJ.
Thank you, Mr. Khallil. Thank you for returning today. You're excused.
Yes, thank you very much, Chief Justice, and thank you to all the commissioners. I appreciate the opportunity. Chief Justice, I will write formally to the Secretary of the JSC.
No, you need not do that.
Oh, I need not.
She's right here. You are on record.
Okay.
This is what you did is far better than a letter that may get lost in the mail.
Certainly. Thank you very much once again.
Thank you.
I thank you.